Okay, let's unpack this. When we talk about justice, especially, the most severe punishment society can impose the death penalty. Where exactly do we draw the line, particularly when it comes to age?
Yeah, that's the core question.
So today we're doing a deep dive into the interpretation of the cruel and unusual punishment clause. That's
Hmm.
the Eighth Amendment, specifically looking at capital punishment for juveniles.
Right.
We've got a stack of critical articles, legal analyses, Supreme Court opinions, all focused on one really landmark case.
Hmm.
Our mission today is basically to cut through the legal jargon, the arguments, and pull out the key insights into this, well, incredibly complex and often really emotional topic.
And what's so compelling here, I think, is how it really forces us to grapple with these fundamental questions, like how do evolving societal values actually shape our laws?
Right.
How should judges interpret documents like the Constitution? And what does cruel and unusual even mean today?
Hmm.
It's this point where law and morality, they don't just intersect.
They collide.
They
Yeah, like-
really collide, yeah. And the Supreme Court has had to figure out how to handle that collision.
So let's start with that foundation, the Eighth Amendment. It prohibits cruel and unusual punishments. Sounds straightforward, but its meaning, fiercely debated. How has the Supreme Court historically tackled this, especially for something like capital punishment?
Well, the death penalty's journey through U.S. law has been anything but simple. You kind of have to go back to 1972, Furman v. Georgia.
Okay.
The Supreme Court actually put a halt, a moratorium, on capital punishment nationwide then.
Wow, nationwide.
Yeah. The court found its application was so inconsistent, so arbitrary, they used words like wanton and freakish, that it made it cruel and unusual in practice.
Yeah.
So essentially, pause button pushed.
So they hit the brakes on it, but that pause didn't last forever, did it? What brought it back?
No, it didn't. Just 4 years later, 1976, Gregg v. Georgia. Death penalty's back on.
What changed?
Well, the states basically learned from Furman. They rewrote their laws, added new safeguards, trying to prevent that arbitrary application.
Ah, okay. Like what?
Things like bifurcated trials. So you have a separate phase for guilt and then one for sentencing. And also something called proportionality review.
Proportionality review.
Yeah, making sure the punishment fits the crime compared to similar cases in that state. If you step back, this whole period shows this constant tension in how we handle law, right? Between the literal words and, well, the ethical side of applying it in what the court itself called a maturing society.
That's a great overview of the bigger picture. But like you said, our focus today is narrower and maybe even more contentious. How does this cruel and unusual idea apply when the person who committed the crime is a juvenile?
Under 18 at the time.
Right, under 18.
And this takes us to a really profound question. Does someone's age when they commit a horrific crime fundamentally change how we, as a society, think they should be punished? And, crucially, how the Constitution should be read.
And that leads us right to the case.
It leads us right to the pivotal 2005 case, Roper v. Simmons.
Roper v. Simmons. Okay, this is the core of our deep dive today. Our sources lay out the two main sides from the Supreme Court. You've got Justice Anthony Kennedy's majority opinion that prohibited juvenile executions, and then Justice Antonin Scalia's very strong dissent arguing they should be allowed.
Two very different views.
Definitely. Let's start with the yes argument, the majority view from Kennedy. He concluded the Constitution does ban executing someone who was under 18 when they committed their crime. That's a big statement, right? Overturning previous decisions. What was his main reasoning?
It was a huge shift, yeah. Justice Kennedy's argument was built on several connected pillars. First, he really anchored it in this idea of evolving standards of decency.
Okay, that phrase again.
Right. He argued the Eighth Amendment's meaning isn't sort of frozen in time, back in the 1700s. It has to be interpreted based on society's current standards, how we understand decency now, what might have been okay centuries ago or even just decades ago might not be today.
So a kind of living constitution idea, and a key part of that for him was finding a national consensus. But how did he find one? Because, at the time, wasn't it only like 17 states that had explicitly banned juvenile executions?
Yeah, 17.
17 out of 50? That doesn't immediately scream consensus to everyone.
That's a really important point you raise. Kennedy did cite this national consensus. He pointed to the evidence. 12 states had banned it by law. Another 5 through court decisions, so that's 17 states where it's considered unusual.
Okay.
And he also noted that 8 states had actually banned executing under 18s before an earlier case, Stanford v. Kentucky, back in '89. So for the majority, this number, showing this significant shift across different states, It showed a clear trend.
Ah, so it was about the direction things were heading.
Exactly. A powerful sign of changing values, even if it wasn't, 26 states. It was about the momentum.
And it wasn't just what states were doing here, was it? Our sources say international views mattered a lot to Kennedy, too.
Absolutely. That was another big piece. He highlighted what he termed the overwhelming weight of international opinion. He specifically mentioned the UN Convention on the Rights of the Child, which flat out prohibits juvenile capital punishment. He noted that at that time, the U.S. was basically alone among developed nations and really among most countries globally in allowing it.
Wow.
He listed examples: France, Germany, the U.K., Russia, China, even places like Iran, Pakistan, Saudi Arabia, Nigeria, India, all banned it for juveniles.
So this global view was key for him in figuring out what cruel and unusual means now.
For Kennedy, yes. It was vital for understanding the term in a modern globalized context, basically asking, should the U.S. be such an outlier on this?
Okay, so that's the consensus argument, domestic and international, but he also focused on the kids themselves, right? How they're different from adults.
Yes, this was the final and maybe the most persuasive pillar of his argument. He really stressed the fundamental differences in culpability between juveniles and adults. He laid out three general distinctions. First, lack of maturity and an underdeveloped sense of responsibility compared to adults.
Makes sense.
Second, they're more vulnerable, to negative influences, peer pressure. And third, their character isn't fully formed yet. It's less fixed, more capable of change, of rehabilitation.
Okay.
And he drew a direct line to an earlier case, Atkins v. Virginia, from 2002.
That was the one about intellectual disabilities.
Exactly. Prohibiting executions for individuals with intellectual disabilities.
Yeah.
Kennedy applied similar logic, concluding that juveniles are inherently less culpable than the average criminal.
Less culpable.
Meaning the main justification for the death penalty, retribution, just doesn't apply with the same force to them.
So Kennedy put together this really layered argument, evolving standards, state trends, international opinion, developmental science. But as anyone familiar with the court knows, where you find that kind of broad constitutional view?
You often find Justice Scalia waiting with a very different take.
Exactly. And he had a fundamentally different judicial philosophy. So walk us through Scalia's no argument in his dissent.
Scalia's dissent was, rooted in a totally different view of what judges should do. His main point was that the Eighth Amendment should be interpreted based on its original meaning.
Not evolving standards.
Definitely not evolving standards. He believed the court's job wasn't to make law based on changing opinions or science, but to stick strictly to the Constitution's text as people understood it when it was written.
So originalism.
Pure originalism. He saw the majority's approach as basically judicial activism judges imposing their modern moral views onto an old document. He thought that was illegitimate.
And he clearly didn't buy Kennedy's national consensus idea either. That 17 or 18 states thing really seemed to bother him.
Oh, absolutely. He ripped into that claim. He argued legislative action, but like you said, only 18 states, a minority, was nowhere near enough to declare a practice unusual constitutionally for the whole country.
His point being, if most states still allowed it,
then there's obviously no consensus against it. He felt the court was just ignoring the will of the people expressed through state laws, favoring its own preference.
And what about Kennedy bringing in international law? Scalia was famously skeptical of that.
Skeptical is putting it mildly. Scalia completely rejected using international law or norms to interpret the U.S. Constitution. He saw it as totally irrelevant.
Irrelevant.
Yeah. He argued the Constitution is an American document for American courts. What other countries do is their business, not a factor in figuring out what our Constitution means. Period. He also pointed back to older Supreme Court cases.
Like Stanford.
Exactly. Stanford v. Kentucky, Thompson v. Oklahoma.
Yeah.
Cases that had previously said executing 16 and 17-year-olds was constitutional. He accused the majority of just overturning settled law based on, subjective feelings rather than solid legal reasoning or original intent.
Okay, and finally, his view on juvenile culpability. Did he accept Kennedy's point that teens are fundamentally less responsible?
Not really, no. Scalia was very skeptical of this blanket idea that everyone under 18 automatically lacks the required culpability.
He thought some could be mature enough.
He argued many 16 and 17-year-olds absolutely can understand the gravity of their crimes and should be held accountable like adults for terrible offenses. He saw the majority's decision as imposing a personal moral judgment, drawing an arbitrary line at 18, rather than following objective law or what the people through their legislatures decided.
So, stepping back from the specifics of Roper, What does this clash tell us? These two opinions, Kennedy's and Scalia's, they really spotlight these deeply different ways of looking at the Constitution and what courts should do, don't they?
Absolutely. It's way more than just a case about sentencing kids.
Right. It's like a window into these fundamental fights over how our laws work and change.
For sure. Roper v. Simmons is almost a perfect example of this clash between judicial activism and judicial restraint. Kennedy's approach, looking at evolving standards, international norms, that's classic living Constitution.
The idea that the Constitution adapts.
Exactly. Which often means a more activist role for judges, interpreting the Constitution based on today's understanding. Scalia's dissent, though, is pure originalism. Stick to the text's historical meaning, period.
Which means more judicial restraint.
Right, leave the changing of laws to the legislatures, not the courts. It forces you to ask, what is the court's main job? Reflect societal values, or just apply the text as written, even if it feels outdated. Roper puts that tension front and center.
And it's striking to remember that before Roper, the U.S. really stood out, especially on juvenile executions compared to other developed countries.
It really did. And being an outlier like that has consequences. Even though many countries still have the death penalty, the U.S. allowing it for juveniles was unique among its peers.
And that affected things internationally.
Yeah, it often came up in human rights discussions, affected diplomatic relations, how the U.S. was perceived regarding commitment to universal human rights standards. Roper brought the U.S. more in line with global norms on this specific issue, which definitely shifted things a bit on the world stage.
So, this deep dive, it's not just history or legal theory. It really hits at how we as a society define justice, define punishment, and how we view adolescence and responsibility. When you hear these arguments about culpability, maturity, where do you think that line is? Does a 17-year-old have the same moral understanding as a 30-year-old?
And that's the tough part, isn't it? What really stands out here is how these legal arguments force all of us to check our own assumptions. Assumptions about fairness, about rehabilitation, about how much power the state should have. You see how complex and deeply felt these constitutional phrases become when you apply them to real lives, especially young lives. It really invites you, the listener, to think about your own views on balancing justice with age, culpability, and society's changing values. And maybe consider this. If our understanding of cruel and unusual really does evolve with society and science, like Kennedy argued, how might future courts adapt that idea? Maybe to new understandings of brain development, or even, I don't know, technological changes we can't foresee yet, in totally different areas of law.
That's a lot to chew on. And that's it for this deep dive into the Eighth Amendment and juvenile capital punishment. We hope it's given you plenty to think about and maybe a valuable shortcut to getting up to speed on this really crucial legal and ethical debate.